Senate Bill 558, filed by Senator Aaron Grail on February 10th, aims to create legally enforceable post-adoption contact contracts. If passed, the bill will allow adopted children 14 and up to have contact with their legal relatives under specific agreements. My Choice Adoption attorney Melanie Coates says that she is a big proponent of open adoption.
That there should be continued communication between the adoptive family and the child and the biological family. The only time that I don't think that is a good situation is when it's not in the child's best interest, if it's dangerous, somehow unsafe.
Adoption is a long process, but once it is finalized, birth relatives typically lose legal rights to contact unless an informal agreement is made. In the bill, SB 558, it does not specify what is needed to make these contact contracts happen. A lot of money goes into adoption processes, and Attorney Coates says this is what she finds an issue with.
Reading through it, it says it requires mediation, for instance. So who's going to pay for mediation? It doesn't spell it out in here who's going to do that. And mediation's super expensive, and it requires 2 mediations. And then one of the phrases I see in here is like, if the response by the biological or legal family is not satisfactory, well, who decides what's satisfactory?
As the bill moves through the legislative process, lawmakers and legal experts will continue to debate its impact. Whether it becomes a law remains to be seen, but for now, it's sparking important conversations about post-adoption rights in Florida.
From a practical standpoint, I see some issues, but I think the idea is great. I think it's a great starting point. I think that, we can build on this and make a really good bill that will help kids. I think they're starting in the right direction.
For SJGC Capitol Bureau, I'm Cynthia Frage.